Missouri Attorney General wanted such restrictions of the government's ability to suppress speech that she classified it or categorized it as potentially hamstringing the government. Yes, 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 we are hamstringing the government because that is what a free people does. Welcome, everybody. Welcome to this edition of Crashes and Taxes. Today is March 21st, Thursday. You will see this early next week for when it gets produced. But that is where we are. And I don't want to do slides with you today. I want to give you some legal updates that I think are really important with what's going on. And so let's get started. As far as market updates go, I mean, the Fed, I was on the stock exchange yesterday for Fed Day and with Fox Business. And basically, the Fed really just reinforced markets, even though the markets had already pulled back. So in December, when the FOMC met and they paused and we saw the dot plot, we expected 3 rate cuts. However, the market immediately in December priced in 6. It was December. It was the beginning of the new year for 2024. It was the last meeting of the year for 2023. And so the market got ahead of its skis and said, oh, if we're going to have rate cuts, we're going to have 6, not 3. The Fed doesn't know what it's talking about. And they priced in 6. Now they're finally understanding that things are going to go more slowly. Things are going to be more methodically handled by the Fed. They're going to make sure that they have enough support to cut rates. That inflationary data, which has been sticky in the last 2 CPI prints, January, February, and as well as PPI came in hot as well last week. So we see that inflation is sticky. And so the Fed is taking their time. But they did send the markets were all slightly negative yesterday at 2 o'clock. And I was literally on the stock exchange when the announcement came out at 2 o'clock that the dot plot still showed 3 cuts. And when the market heard that we still are going to have 3 cuts, the market was excited about that and did turn to the green. In fact, we hit a new high with the Dow and S&P all on immediately as soon as the announcement was made. So I think that we, all the things that we've discussed, all of the, cutting of the rates, the liquidity issues with banks, the commercial real estate, the biggest issue that we have it as an immediately pressing, time sensitive is the refinancing of just under $1 trillion of commercial real estate this year. We had some workout loans that were done in 2023, trying to give extra time into 2024 when the market assumed the Fed would have cut rates already. And since that's not happening, it's taking, you are going to see, a substantial amount of this $1 trillion that's already been worked through until 2024 have to get refinanced at higher rates. And that is, in fact, going to cause banking issues. And that's why the Federal Reserve has already put in its beige book, its minutes, that, in fact, we will have bank failures this year. And so the Fed is counting on it. We should count on it. And that's the point. So the markets are irrationally exuberant, in my opinion, for everything that is happening, everything that is going on in the world. And we're just going to have to deal through that exuberance as things begin to happen and the market does begin to go. And we see that this is really, truly an equity bubble of our own creation through stimulus, because we still have $6.1 trillion in money market funds. That includes all of the $4.7 trillion in additional commercial bank deposits, and then, money market funds that are in investment banks. So we still have a lot of economists that believe that there's a long equity runway because they believe that the money will leave the money market in the banks as rates cut. But the truth is, that is not going to be the case if we do have an asset bubble collapse. So what I want to talk to you about today, though, is completely different. It's really the legal framework of 2 major areas that this administration and that are facing our country in general that I want to kind of walk through, because, it's crashes and taxes. Taxes involves politics. I had once had somebody write me that listened to Crashes and Taxes and was irritated and upset with me, actually, for doing a previous Crashes and Taxes on political issues. and wrote to me and thought, you're out of your wheelhouse. Well, first of all, I'm not out of my wheelhouse. I am an attorney. I do understand the legal framework of this country, the Constitution, the local, state, and federal government, and the division of power. So certainly I am well within my right to discuss legal items as an attorney, but political items and political elections affect tax policy. So it is absolutely something that someone of my, intellectual bent would want to discuss. So I want to go first and give you this kind of announcement. And I didn't do slides today because I just want you to see. So you can see here, this is the New York Times. This is 9 hours ago. You can see Biden administration announces rule aimed at expanding electric vehicles. And basically what's happening is, and this was much more aggressive, UAW, United Auto Workers, basically negotiated reducing this. But what the EPA is doing is really a mandate to force car manufacturers to move to electric vehicles, which are called broadly EVs. And the reason that they're moving and forcing them to move to EVs is because they are reducing the tailpipe emission threshold that they are allowing car manufacturers to continue to resonate at. And so as they reduce tailpipe emissions, that makes more and more of the car manufacturer have to produce electric vehicles to be able to maintain the overall reduced tailpipe emissions requirements that the EPA is setting. Now, this is basically ruling by executive branch fiat without elected officials on who gets to actually have, what a private business in America will be producing, whether it's Tesla, whether it's Ford, whether it's GM. Through the rulemaking process at an executive agency, we have the EPA forcing, basically, in essence, car manufacturers to move to electric vehicles. The problem with that is that the global population is starting to revolt against electric vehicles. If you look even at Ford right now, you have a lot of their electric vehicles that are literally selling below MSRP because the demand is not there. We know that the vehicles are more expensive, obviously, on the front end, but they certainly are vastly more expensive to maintain. I have a Tesla, and full disclosure, I received, a kind of just a random notice that, Tesla batteries can be almost as expensive as an intro level car to even replace. So it's not the ownership and the maintenance are an issue, but what I want to say is we heard two cases in January of 2024, January 17th, and the USSC heard two cases, and that was Loper Bright Enterprises and Relentless. And basically, the point of these, it was a fisheries case in which similarly a rule had been made by our executive agency to tell commercial fishing boats that they were responsible for paying the cost of an observer, that basically Congress had passed a law that there has to be some kind of observer on certain type of fishing expeditions or to maintain fishery levels or whatever. I didn't care about the semantics and the technicalities of it. That's not the point. The point is that a rule was passed by an executive agency, and then it was interpreted by that agency to put the cost burden of that new rule onto the companies that are the fisheries themselves. And so the fisheries sued. And when they sued, they lost at the lower level. And they lost at the lower level through something called, and I did an entire podcast on this earlier, called the Chevron deference or Chevron doctrine. And basically in the law in 1984, the Supreme Court interpreted a case that basically said if Congress passes a law that is ambiguous and therefore we don't know how to implement it and to actually enforce it. So to understand a basic division of our federal government, we have three branches of government. We have the executive, the legislative, and the judicial. The legislative writes the laws. The executive branch enforces the laws, and the judicial branch interprets the laws. So whenever these are how the three branches work together, the legislative passes, the executive enforces, the judicial interprets. What was happening is through the USSC Supreme Court case law, of Chevron deference, what the court basically said, the Supreme Court said in 1984, this was before the administrative state was as it is today, but it was certainly on its way since the 70s. What you saw in 84 was the USSC saying that Congress is passing these technical laws that really require knowledge and deep expertise, and Congress doesn't have it. And since Congress doesn't have it, they will know that there's a problem. They know that they need to pass a law, but they are not going to have the technical expertise to really granularly nuance out how to enforce that law. And so what happens is executive agencies like the Environmental Protection Agency, like the any one of these agencies, take your pick, basically as they have the expertise in environmental protection, they will be able to promulgate rules to enforce the law that are reasonable. And the test was, first, a law has to be ambiguous. That has to be passed first before there'll be any kind of deference. And then second, if the law is ambiguous, then any interpretation or any rulemaking by the executive agency will be respected or deferred to. In other words, the judicial branch, when interpreting the laws, will defer to the executive branch, and specifically the administrative agency that wrote the rule on how they're going to enforce the law. They will defer to them. So what happened over, you can imagine, since 1984, which is literally in 2024, 40 years now that this doctrine has been in place, is you had just carte blanche of executive agencies writing these really technically specified rules, passing cost burdens, making rules, putting them onto the business, the consumer, the taxpayer, without any real legal redress. Because if they found something was wrong or if something was not right and they tried for redress, well, they would go before a judicial system that literally deferred to the rulemaking process of the executive agency. There's no real ability for redress. And that is what the Loper and the Relentless case really brought to the forefront on January 17th of 2024 to the U.S. Supreme Court. And so what is happening is we generally are expecting potentially that the jurisprudence case law of Chevron might be overturned, likely will be overturned. And if it's overturned, that upends the administrative executive agency state that we know, because it will once again force Congress to, one, make laws that are less ambiguous. It can just be deferred to really an executive agency truly writing and the rules of enforcing the law. It has to be more granular, it has to be less ambiguous. And two, that it's the judicial department and the courts that are to be the redress and to interpret the laws, not to defer to whatever the executive rulemaking body has said the rules are. You defer to the body that's making the rules on how to enforce them, and you're going to get a lot of problems. And that's where we are, and that's what we have. So it's just very interesting that just after this January 17th USSC hearing of these two cases, and the fact that Chevron is very likely to be overturned this June, we have the EPA coming out and forcing basically car manufacturers to move towards electric vehicles simply by reducing the amount of tailpipe emissions by year that car manufacturers are allowed to have as an allowance on the cars that they're producing. So this is a big problem. The second case I really wanted to go through today is Murthy versus Missouri, which was just heard on Monday, March 18th, this past Monday, this week, in front of the United States Supreme Court. And literally, this is a little bit more concerning to me because in this particular case, you had Justice Jackson, newly appointed by Biden, Justice Jackson, that basically made this statement that, so do you see the First Amendment? If you want to interpret the First Amendment, Missouri, the way you're interpreting it, it seems to me, she said, that you are really going to be hamstringing legitimate government function. And I thought the Attorney General, I believe it was from Missouri, don't quote me, might have been a different state because there was 2 states represented. But anyways, I thought he did a really good job of saying that the solution for the government and any kind of government, legitimate government need is not to censor the speech of others, but to just create more speech themselves. So in other words, if you have social media posts, and the case was really dealing directly with what happened through the 2020 coronavirus situation in our nation, because the Biden administration had a secret portal that basically they would go to request certain medical professionals to be either their posts removed or for them to be shadow banned, which would basically be their posts seem like they're still out there publicly, but they're not being displayed to anybody. So it's not a direct form of censorship because the post is there. It's just not visible to anyone. So it's not really there. It's in all effectively it's been muted, and therefore it's moot. It's really been censored. So that is basically what happened. And through all of this process, there were some processes that were uncovered of databases where both state, local, and even the federal government had direct kind of interaction directly with the social media companies. And the oral argument, if you go back and you really listen to the oral argument of the Supreme Court, which I encourage you to do as an American, because this is about your First Amendment rights. And the First Amendment is really in any kind of republic. Most people think we're a democracy. We're not. We're a constitutional republic, which basically just means that we hold population-wide elections, that we elect people to represent us to then go and pick leaders. So it is a 2-step process of a republic, not just a direct vote democracy. And that was designed by the founding fathers for numerous reasons. But the fact is that if you don't have a free press, if you are only allowed to speak under what the government assumes is a good viewpoint or an acceptable viewpoint, then you do not have a people government. You have a government. And I was really shocked because the First Amendment, the Bill of Rights, the Bill of Rights is our 10 first amendments, our first 10 amendments to the Constitution. And they were absolutely written as a prohibition against government becoming too big, and the government basically, that the people live to support the government and the government decides how society works and not the other way around. Our government was truly designed, our federal government was truly designed to be small, lean, only pick up the national tasks that the states could not handle themselves because they would be individual states, 50 individual states. And of course, it wasn't 50 at the time, but the fact of the matter is that we grew to 50 states, and those 50 states are not able to do everything. But everything from a federal level, anything that is not specifically, explicitly reserved for the federal government is reserved back to the state. So anything that the federal government does not have as explicitly its powers is by default of our Constitution and our federalistic system reserved to the states. And so we have seen an overstepping of the federal government. But now with this censorship case that was just heard, Murthy versus Missouri, it used to be formerly Murphy versus Biden, it is something, Missouri versus Biden, it is something that is a huge deal. Like when I listen to Justice Jackson state that it was apparent that the Missouri Attorney General wanted such restrictions of the government's ability to suppress speech that she classified it or categorized it as potentially hamstringing the government. Yes, we are hamstringing the government because that is what a free people does. There will be nut job opinions out there. You might not like my opinion. You might not want it to be on YouTube, but it is a part of our American fabric that we have open ability to have that opinion. Now, the government might argue, well, that doesn't mean that it has to be broadcast on a PA system across the public square. And the government might not prefer that it be housed on a platform that is available to millions of people. They might want to curtail, those opinions that they don't agree with. But that is censorship. That is the definition of censorship. And if we are to preserve a free society, a society that has a government that is accountable to its people, then we must have the First Amendment, and we must have it in an effective way, not a way that can be curtailed by the government deciding which opinions to minimize and or shadow ban, and which opinions to promote because it follows the narrative of whatever administration or whatever political party or whatever political group or whatever NGO wants to push on the American people that week, that month, that year, or for the good of their view of society. People have different political opinions. This country has never been so polarized and divided, except for during the Civil War, when we were actually at war between ourselves. We are there. There's a movie coming out next month called Civil War, which is about us really imploding from the inside and ripping each other to shreds. We could easily destroy ourselves from within. But this is the first way to do it, to have a Supreme Court justice who espouses during oral argument the viewpoint that the First Amendment could potentially so hamstring the government that it needs to be curtailed is, in fact, a problem. It's a litmus test that every justice that goes on that court should know that we are a republic, that we are a government beholden to the people, not the other way around, and that the First Amendment should never be handicapped by the federal government, by the state government, or by any kind of local government. That freedom of speech is the only way to hold the government accountable. And when the government gets to start deciding what opinions it agrees with or doesn't agree with, and what opinions it wants to put in the shadows and what opinions it wants to bring out in the sunlight, then we have lost the people's control of the government. And if you weren't aware, that has already happened. We have lost our abilities to self-govern and to control our federal government. It is beyond the pale. Now, this is a huge issue for us at this particular time because we just had a judge rule in a Second Amendment criminal case of an illegal alien, an immigrant that came in illegally, which we've had so many, as you guys know, this year. I'm just pulling up the article because I've got articles all around for this podcast. I'm just pulling up the article that came out both in Fox News and the Daily Mail, which is obviously a British publication. But basically, the Obama appointee judge, Sharon Johnson Coleman, out of Illinois. She's the federal judge out of Illinois, district federal judge. This is the first level of federal judge. Sharon Johnson Coleman, she ruled earlier there was a case against a illegal immigrant under U.S. Code 18, Section 922, which prevents illegal immigrants from carrying guns or ammunition. They're not in our country legally. Therefore, under U.S. 18, 922, we see that they are not allowed to have guns or ammunition. But in her ruling, she struck down the U.S. 18 U.S.C. 922 G5, and she wrote, the non-citizen possession statute violates the Second Amendment as applied to this illegal immigrant, the name of the person. And thus, she granted the motion to dismiss. So what I want you to understand here is the Biden administration, for whatever their reasons are, I have my opinion about what their reasons are, which are actually multifaceted and very intricately weaved globally. But they have decided to bring in millions and millions of people that are not able to come to the United States legally. And there's all kinds of asylum claims, economic asylum claims. Look, we don't grant asylum for economic reasons because the entire world, the entire third world nations could request to come to the United States of the status of their country as a third world. So that is not a valid asylum case. Yet these people are coming in droves. The Remain in Mexico policy that was done through executive order by Trump has been rescinded. All of Trump's border executive orders have been rescinded, which is why the border is wide open, back like it was, but way worse than even under Obama, which is shocking. Never thought I'd say that. And what that means is we have these people coming over in the court, if the court interprets, the Supreme Court has interpreted that illegal immigrants, migrants, aliens, whatever you want to call them, illegal persons that are here, that they have rights to due process on the Fourth, Fifth, and Sixth Amendment. But we have not directly applied through case law the Bill of Rights to illegal persons that are crossing our border illegally. And we have specifically federal law that, in fact, prevents that. So now we have a constitutional situation. We have a district judge dismissing a gun charge against an illegal. And now you have all of the NGOs, you have all of the groups that get money from the federal government that actually are the ones that bring people here, like the Catholic Charities Group, all these NGOs that are massively government funded, federally government funded. But these are the groups that are like using the Customs and Border Patrol One app, the CBP One app, that basically immigrants all over the world can go in, create a profile, request asylum, and then the NGO gets notified through the federal government, through the CB1 app. Information gets disseminated to the NGOs, then pick that person up and fly them into the country. You know, the Biden administration has flown in over 300,000 people directly from countries into our country, into 43 different airports. They're just, you know, the very beginning of in the last year, just through this one CB1 app program alone. So now if we're going to decide as a country that these people can be here, or are here, and we're actually facilitating it through many ways, but they are here, and now they can also have the Bill of Rights applied to them, which means they have the right to bear arms. Now you've got a massive problem, because now you've basically just interpreted your own Constitution, which is your founding document for your country. You've interpreted it in such a way that, in fact, nullifies it. And let me clarify what I mean by that. If you're going to interpret the Constitution to say that the word people, because the word citizen is not in the Bill of Rights, so that is how it's been interpreted, to say, hey, the Bill of Rights does not use the word citizen, it uses the word people. And so therefore, because it uses the word people, it is not reflecting just citizens versus residents versus illegal people that have broken our immigration laws and come here illegally. That is what they have done. If you're not going to differentiate in the application of the Bill of Rights against those categories of people, then you have basically nullified your country, because we have an administration that is not enforcing our border, that is leaving the border wide open. In fact, is fighting the state of Texas against very hard to enforce their new law, SB4, which SB4 allows the state of Texas to say that it is a Texas crime to come into the state of Texas illegally through not through a port of entry. So all of these people that are coming through non-ports of entries are criminals under Texas law that can be arrested and deported. The Supreme Court ruled literally on Tuesday that they could that the enjoyment of that statute was no longer going to happen, and that Texas could now start to enforce their new SB4. Within hours, the Fifth Circuit came back and said, no, we're going to pause again. We're going to have another hearing on this SB4. So we're going to still enjoin Texas from enforcing it. So I'm just telling you, we have such bizarre things happening. And of course, we would, as we get to this stage of constitutional crisis, because we have lawlessness taking over. And I don't care if you're a fan of Biden or you're a progressive or a liberal. I don't care. I'm not against those people. Most of my friends, because of all the liberal schools I attended, most of my friends are extremely progressive and extremely liberal. And I don't care. That doesn't bother me at all. But it is not a progressive tenet. It is not a liberal tenet to want to destroy a country. A country without borders is not a country. If there are no borders, there is no country. A sovereign nation must, by definition, have borders. And if it has borders that are not respected, and then people are able to come in without the process of law, they're able to come in, and they do come in, and then those same people are counted in our census for government appropriations by territory. Those same people are allowed to carry weapons and potentially create whatever havoc they want to create because they're economically disadvantaged. They don't have jobs. They don't have what they need in the terms of, establishing a life here. They come out to attack American citizens. We do not have to accept as an American population the systematic nullification through interpretation of our Constitution. Let me say that again. We do not, as Americans, have to accept the systematic nullification of our Constitution through its interpretation judicially. In other words, if these judges are going to rule that the Obama administration has the ability to enforce the immigration laws or not enforce the immigration laws as they so choose, which means the borders are open, and in the same breath, the same judicial system is going to interpret that once people get here, they are, quote, quote, people as defined under the Bill of Rights, and therefore they have all 10 Bill of Rights that apply to them. The Bill of Rights is the first 10 amendments. The other amendments post the 10 are not considered the Bill of Rights. If the Bill of Rights applies to a person who is in this country, regardless of how they got here and regardless of their legal status, then again, we have nullified our Constitution by basically saying the whole of the earth is allowed to be here. The whole of the earth has the Bill of Rights, and there's no differentiation between a legal American citizen or a legally recognized green card permanent resident or a visa recognized legal status versus an illegal who just crossed our border. We are nullifying our Constitution through its interpretation, and we do not have to accept that. We can say, no, the founding fathers would not have said that illegal people that come to our country get the right to own a gun and wield it however they may. So this is a precipice legally that we are getting to. And we have to figure out how we're going to move forward from this. This is a very, very, very dangerous time with the case law and the cases that we're seeing. And we're just being pushed into lawlessness so quickly. I cannot believe in 3 years how much this country has moved to lawlessness. And it's not about, we've had multiple Democratic presidents, even Obama. We didn't move to lawlessness during them. So this is a change. This is a difference. And we as American people need to wake up, get involved, and start to say, no, we're not going to accept this kind of interpretation of our Supreme Court, because you are, in fact, nullifying the sanctity of the fact that we are a separate, autonomous, independent, and sovereign nation. And that's what I have for you guys today, is a legal update mostly I wanted to give you, and I hope that you enjoyed it. Until next week, have a great week, everybody. Take care.